Conflicts of interest in mediation. Part of the series, Mediation with or Without Attorneys with Ty Bourdony. This is our topic for today.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent.
Hello and welcome. My name is Natalia Łowska-Czajka, and I welcome you from Warsaw, Poland, where I practice as an advocate and a mediator.
Hi, everyone. This is Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
And I'm Ty Bourdony, the Director of Mediation at CPLS, a downtown Orlando law firm, and a primary mediation trainer in Florida.
Ty, it's great to have you back with us. And today we are going to touch upon a topic that is of the utmost importance in any mediation, because actually it's a topic that guarantees whether this mediation is a successful one and brings a solution to the parties or not. And this topic is conflict of interest, where you are, Ty, in Florida, and both Mac and I are also Supreme Court family law certified mediators in Florida. So we are also familiar with that. We know how strict it is, how important it is to know, understand, and follow the rules that regard the conflict of interest. Tell us some more about it, please.
Yeah, so, just the facts of life are that life is complicated, and we lead lives that take us in so many different directions, and you just never know when you're going to have a conflict of interest. In a mediation that you're either been chosen or agreed upon to serve or assigned as a mediator to serve as the mediator for that case, and sometimes it just happens that there's any one of a number of different issues that arise, and there could be conflicts of interest, right? That and the mediator, we have to make sure that there aren't conflicts of interest, that we can be everyone's neutral mediator, right? And so it's something that a mediator has to always have in the back of their head, and so our standards of practice always need to start with this in place. It's just the matter of the way we do business, so to speak, is so long as there's no conflicts, okay, let's go on and sure, I can mediate. And so maybe now is a good time we can pull up the rule, and then we'll be practical about the way I see it. And that is, I think, the Florida rules for certified mediators, and its rule, and I've got to look because I don't remember them off the top of my head. The number is 10.340 is that rule, and then you can pull it up and make it large for the parties to see. Right, there we go.
Yes, and if you're listening to the audio version of the podcast, be sure to check out the YouTube version of this just by going to the YouTube channel Lawyers and Mediators International.
So, maybe let me just start. Let me read, from it. And let's start with, A. And generally a mediator shall not mediate a matter that presents a clear or undisclosed conflict of interest. And so what is a conflict of interest, or when does it arise? It arises when any relationship between the mediator and the mediation participants or the subject matter of the dispute compromises or appears to compromise who? The mediator's impartiality. And so what are some of the practical ways that comes up? Well, when I was the staff mediator at the courthouse in the Ninth Circuit in Osceola County in Florida, so you see parties continually, right? Attorneys, for instance, you'll see them on a regular basis. So does just because I've mediated with an attorney before, does that mean now I have a conflict of interest? And or What if I went to law school with an attorney, right? Now, do I have a conflict of interest? What if I go out socially with that attorney? What if I have a business interest with somebody? What if, or other issues? What if, for instance, this actually happened to me? I purchased a home, and when I purchased the home, I didn't realize, but the real estate agent who I purchased the home from was married to an attorney, and that attorney was 2 weeks later was one of the attorneys in a family case that I had to mediate, and I only realized that was the case because when I was signing when you go to sign your life away for a mortgage, right? When you go to buy the house, when I walked in, I saw that there was this attorney's office who I knew very well. And they happened to be the attorney who I was going to be mediating with in 2 weeks. And so I went in, I said, hi. I said, what do oh, I'm married to the realtor. And I was like, oh, wow. And immediately in my head, I was like, I'm going to have to disclose this to the other party. Right. So that's just an example, for instance. But and by the same token, there are certain procedures that mediators have to have in place. The very first thing that we will do, for instance, at the firm, and a mediator should do, is you should perform a conflict check, right? As you are either assigned or accept a new case, you're going to want to make sure that you haven't mediated with the parties before. And if you're part of a firm, has anyone in your firm mediated with these parties before? So you want to perform a conflict check. If when you send out your engagement letter, right, you should let the parties know if there are any conflicts of interest, for instance, or in my case, and that's not going to happen often. How often am I ever going to be in a situation like that before? No, they're sometimes quite unique. You can't make up these stories. But the point of the matter is, once you realize that there's a conflict, there's a burden of disclosure, which is B, for instance, right? The burden of disclosure, let me read from it, of any potential conflict of interest rests on whom? The mediator. Disclosure shall be made as soon as practical after the mediator becomes aware of the interest or relationship giving rise to the potential conflict. Right? So as soon as you know, you disclose. Now, interestingly, sometimes you don't recognize any conflict, then you're mediating, and then something happens and you realize that you do have a conflict. So it happened to be a family mediation, and I was we were doing child support. Now, anyone who does family mediation, who practices family law, we're not really going to be working on child support. I mean, people might run guidelines beforehand because they might want to know what they might be looking at, but typically you need to know what the time sharing is between the parties. A lot of things already have to be established. So in my mediations, by the time I'm getting to child support, we've practically been mediating for a while, right? So in this instance, my gosh, we must have been mediating 2-3 hours already. And we get to child support. And so I need to know what everybody's incomes are, right? It's one of the things you need to know. How much does everybody make? And so come to find out that mom, the mother lets us know that she works at Vacation Village. Now, no one listening is going to have it. Why would that matter? Well, but to me, see, my wife is the regional director of marketing for a timeshare company, right? And the timeshare company is Vacation Village. No, I'm sorry. The resort in Orlando is called Vacation Village. So as soon as she said that, right, the alarm bells go off in my mind. And I'm like, oh, well, it's a big company, so I probably don't have to worry. And I said, well, what department do you work in? And then she says, the department that my wife, works for. And I'm like, oh, now I'm much closer. And then, but still, it's not a small department. There are many different, who's your supervisor? And then she says the name of the supervisor. Sure enough, it's the supervisor's boss. My wife, though, I'm like, oh. And immediately, so I said, oh, I disclosed it. And I said, that's my wife. Now we don't know each other, right? But then when I look over at Dad, he's like going like this. And so we also have to disclose as soon as something comes up, right? So, and it could be problematic. And so what I tell my students is as soon as you are aware of the conflict, you stop and you address that issue and no other issue, and you do not move forward until it is cleared up, right? And if what happens if you can't clear it up? Well, so let's go to number C. What's the effect of disclosure? After appropriate disclosure, the mediator may serve if all parties agree. However, if a conflict of interest clearly impairs the mediator's ability to be impartial, then the mediator shall withdraw regardless of the express agreement of the parties. So what are we talking about there? A waivable and a non-waivable, right? Conflict of interest. And so what would a non-waivable conflict be? Like, so for instance, if a sibling of mine, a family member of mine was going through a divorce, should I serve as their? No, no, you should not do that. If a party is so close, no, I should not do that, right? A member of my firm, no, I should not, do that. If it was one of the two of you, of course it's not going to be, no, I should not, do that, because we have a very, close relationship with respect to how we work together and what have you. Now, that case that I talked about, where some individual happened to work not just in my wife's. Now, if they just worked in my wife's company, but they were in a different department, is that a problem? Only if they knew her, had a personal relationship with her or something of that nature. But in this instance, they knew each other, they worked together. Yeah, that could be a problem. But at the end of the day, and we probably spent 5 or 10 minutes on it, right? And I wanted to, what did I want to make sure? I wanted to make sure that Dad was absolutely okay with it. And if I got any hint that he wasn't, I would have simply gotten another mediator, withdrawn. I would have rescheduled it for them. But he was okay with it, and I was very comfortable with the fact that he was okay with it. My mediator's spider sense, so to speak, wasn't going off. I felt okay, and then we continued.
And Ty, in that scenario, did you then have both parties sign some kind of waiver to confirm that fact, or do you just
that's a
move
great
forward?
question. That's a great question. No, I didn't, and the reason I didn't was because my mediator's instinct in that moment was telling me, no, it's okay. They are okay with it, and so I moved forward. Could you have? Sure, you could have, but I would tell you, if you were so worried about it that you thought I'd better protect myself, maybe we should err on the side of caution. If you're not sure, err on the side of caution, right? But I was sure. I was very, very comfortable. I mean, I'm a very experienced mediator, and I hope that I can tell when someone is comfortable and when they're not comfortable, when they're feeling pressured, or when they're not. We're supposed to ensure that no one is under undue pressure, that everyone's right to self-determination is always intact, right? And there are times when you can tell, oh no, something's wrong here, right? So I did not, is the answer. Do you have to do that? No, you don't. Could you do that? Sure, you could. But again, I think just to say, well, they signed something, so I should be fine. Are you fine? I think if there's a conflict, and if there's a conflict, just withdraw. Get them another mediator. You shouldn't move forward if you're worried, right? You shouldn't move forward if you don't think that the parties are empowered, right? That really is what it's all about. It's making sure that there are no conflicts, so that the parties are empowered, so that the parties can mediate their issues. And so long as there are no conflicts, I can be everyone's neutral mediator, and they're going to trust me. When there's a conflict, the issue is, will they trust you, right? And we have to ensure that there are none, to the best of our ability, right? And you will know if there are. And I've been in mediation times, and I'm looking at someone and I'm thinking, I know this person, or they look so familiar. You ask, and do we know each other from anywhere? And then this from here, from there, from no. Oh, okay, then let's move forward. FYI, so.
Yeah. And before I turn it over to
Yeah.
Natalia, real quick, back on section A, where it
Yeah.
basically discusses when a conflict occurs. Okay. A
Hmm.
conflict arises when any relationship between the mediator and the mediation participant compromises or appears to
Hmm.
the mediator's impartiality.
Right.
So that word relationship is very important.
Hmm.
Years ago, when I was in mediation training, we were asking the question, well, what if you are Facebook friends with one of the participants? Okay, you're the
Ooh,
mediator, one of the parties is your Facebook friend. Um, Everyone is a Facebook friend these days. Okay, I know people who have
potentially.
thousands of Facebook friends,
I do.
but
Yeah.
but Facebook is one of those things. Some people use it more for business, and they're not
Hmm.
really your friend. They're just somebody that sent you a request and you accepted it in the many
Right.
cases. So, can you give your opinion? And again, you don't speak for the Supreme Court of Florida or the Office of State Court, but
The dispute
what's
resolution center. Yeah.
yeah, based on your experience and your training experience, how far does this go in
Hmm.
terms of relationships and conflict of
Yeah.
interest? And
It's a
keep in
good
mind, we
question.
only got a few minutes, and Natalia has her, she's biting at
I'll
the
make
bit
it
to speak.
fast. I'll make it fast. So, um, you're probably not going to be someone's Facebook friend. Could it happen? It could happen. And then the question is, are you aware of it? If you're not aware of it and you don't disclose it because you're not aware of it, I no harm, because you're not aware of it. But if you are aware of it, yeah, you need to disclose it. Now, if it's, well, we just happen to be, we live in the same town and we're Facebook friends because we're part of some group. I'm making something up. But if it's something innocuous, if it, but still, you could. By the way, I believe we're Facebook friends because we both go to the same flea market. I don't know. I'm making something up, right? And then, but other than that, we don't know each other, right? There's no issues, and so you just want to make sure to disclose it. Or I've mediated with Natalia so many times because she's a local attorney, right? Let's say I was a Polish mediator. I would say, now, by the way, I've mediated many times with counsel. I haven't mediated with you, but again, it's just because of the nature of the way cases are ordered. Other than that, we don't have a relationship, and then you just keep on moving forward. So the point is, your instincts are also going to inform you. Should you let everyone know? Sure. I think, of course, in the context of your opening statement. But as that level of conflict rises, you're going to know, and then you're going to know how much attention you need to address it.
The question that I might also be bringing about this is, for example, in Poland, we do have a lot of mediation with the banks because of the interest rates that are being
Oh, yeah,
rising, and
yeah,
that's a lot of that goes to the court. Some of the clients claim that they were not properly informed, so the bank didn't do proper disclosure of the risks that are involved. But then the question for the mediator: can you mediate a case with a bank where you are the client of this bank?
yeah. Right.
So
It's a great
you
question.
have your own account there. But I know that we can also expand on that. Everybody should judge it in their own mind and try and be ethical. I can also tell you that, for example, that is also with a homeowners association. For example, there is a
Sure.
manager who owns, or actually who runs certain associations, and
Yeah.
then you happen to be governed by
Yeah.
the same management company. Is it a conflict of interest or not? You just live in the
Mhm.
house and you pay the fees
Yeah.
to this manager.
Yeah.
Do you really have a conflict of interest? Again, depends on the circumstances. However, I would like to point out what stems from this Rule 10 340.a, because you can be having conflict of interest in two forms. One, in a relationship with the parties of any kind, and again, that could be a commercial relationship, a personal relationship that can stem from previous things that you've been either doing together or happen to be, for example, engaged in a car accident, or you are a witness to someone on someone's matter
Sure.
that you are now mediating.
Right.
What I want to point out is that you can also have a conflict of interest when it comes to the subject matter. And this is quite interesting. Of course, I can't imagine a mediator mediating, for example, over a car that the parties are, and that used to be my own car, but I can see things that can be um, dangerous here. And Ty, if you could say quickly something about having a conflict in terms of the subject matter of the mediation.
So I think it's going to be very case by case, of course, right? The closer you are with respect to whatever this issue is, the more your duty is going to go up. But the easy one there is, and this has come up, foreclosure cases, or I do a lot of insurance related cases, right? And so if the financial institution that is foreclosing on someone's home is this my financial institution, right? And should I not mediate that case? I, practically speaking, I can see how I can keep myself neutral. It's not my mortgage. Yeah, we have the same mortgage company, but the institution that runs the mediation, the foreclosure mediation program, their position is, if a mediator is financial institution is the same financial institution as in the issue at hand, that mediator should withdraw. Now they're doing that out of an abundance of caution, right? I can imagine it being waivable. So if there's attorneys in the room and the attorneys, like, let's say it just came up, you didn't realize, maybe you look but there's a second mortgage that you weren't aware of, and that second mortgage is from your financial institution, and mediation has already been going. Then I could say, you know what, I realize that I'm going to choose Bank of America has a second. I'm also with Bank of America. Is everybody okay with that? At that point, and their attorneys, and if they said yes, I would be comfortable moving on, right? But could you imagine an instance where there's a pro se? Could a pro se, but because they don't know, they're nervous. What if they worried about it? So I would. It's better to err on the side of caution than not. Yesterday, I was in an insurance case, and one of the mediators, who is now on my mediation team, was the insurance adjuster, and I didn't know, because I have a paralegal now who kind of schedules everything for me. And so and especially those kinds of cases, you don't typically get pleadings beforehand. And so I jump on, and as soon as the adjuster for the insurance carrier comes on and I saw who it was, I knew immediately. I said, oh boy, I have to disclose this now. And I disclosed it, and the parties were fine with it, and I could tell that they were fine with it. And so, just because, and it was the other side that said, look, we're fine with it. Besides that, I would hate to have to wait 2 weeks, and we really have no problem with it. And so, because of the way I heard them say it, and because I'm always reading the temperature in the room, I decided it's okay, then we can move forward. But I was worried about it. And so afterwards, now I put in, a standard operating procedure. If any, I just won't accept any cases, plain and simple. And I let them know that. So something can happen, and then you have to judge in that moment, can I move forward? Can I not move forward? But afterwards, what can I do to make sure this doesn't happen to me again? Right. So you just never know when it comes up. And I think we have to just be very, not only practical with it, but we have to just make sure that this conflict is it waivable? Do the parties agree? And can I tell that they're okay? Or is someone being forced? If someone's being forced, I'm out of there, right? And or moving forward, I just don't want to be in that position, and it's not worth the money. The party's right to self-determination and that they have a good mediation, that's more important than anything. I'm just simply not going to accept any more cases, with that individual. Or you know what, so I say, when in Rome, mediate the way your Roman program administrator wants you to mediate. So what I'll do is, if I just won't accept any cases where I happen to have the same financial institution any longer. Better to be safe than sorry.
Thank you so much, Ty. So with that, we're wrapping up, and then we'll continue on with this topic a little bit further, or an additional one as well. All right, guys. Stay tuned
Always a
until next time. Thank you.